case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Ms. Higgs, and Ms. Nelson. And the people are represented by Mr. Orman, Ms. Pearson, Ms. Tish McGuire, and Mr. Edson, and someone else that has not entered yet as far as I can remember.
No, my name is Dan Edwards. I have been sworn as Special Deputy District Attorney on this case on May 14th of 2013, and that should be in the court file.
It is in the court file. I just had not met you yet. Good morning. The record should reflect, by the way, that we are outside the presence of the jury. The first thing that I would like to take up is the defense's proposed instruction, jury instruction number 38, because I don't want to forget to do that. We had a bench conference about this on Thursday, right after I read the verdicts. And I, in general, gave the jurors an admonishment that was similar to the one that is contained in proposed instruction number 38, with a couple of exceptions. The last paragraph reads as follows: if any juror has at this time discussed or formed an opinion regarding what penalty should be imposed, or if any juror knows of another juror who has done so, please notify the bailiff. And then the penultimate paragraph reads as follows: you are reminded that regardless of your verdict at the first trial, no juror is ever required to sentence a defendant to death. That penultimate paragraph, I ended up not reading it because I determined that we should have this discussion first, and then that once I give the jury the introductory remarks at the beginning of the sentencing hearing, that I would include something along the lines of the penultimate paragraph in those comments. And so that's why I did not give the jury that particular admonishment or that particular advisement. In terms of the last paragraph, I indicated at the bench that I didn't want to make any decisions without thinking about it and without first hearing from the people as to whether they thought this was appropriate or not. So who wants to address the court with respect to that last paragraph in proposed instruction number 38, or its defendant's proposed jury instruction number 38?
I will, Your Honor. I don't see a need for it. I mean, it's not like we do that regarding the issue of whether they formed an opinion about guilt in the prior phase of this trial. The court admonished them always, don't form any opinions about the case until you go back in the jury room. And I think that it just, the same type of you're not allowed to form an opinion until you start deliberating. But to sort of ask them, well, think about whether you've even given it a moment's thought, I don't think it's appropriate. I don't think it's necessary. And I think actually what this would end up doing is getting them to think about it even more. So I do object to that.
Anything else from you, Ms. Nelson?
No, Your Honor.
I don't think it's appropriate, and I don't think it's required. There's no reason for me to give it. I trust that the jurors are following all my admonishments, and I don't have any reason to believe that there is a concern at this time with respect to this particular issue, and so I won't give that last paragraph. And I already decided with respect to the penultimate paragraph that I will say something along the lines of what's in the penultimate paragraph during the introductory instructions that I give the jury on Wednesday. All right, that takes care of that proposed instruction. Yeah.
I'm sorry to interrupt. Before we proceed, our real time isn't working. I was wondering if I could ask the court reporter quickly to help us get it set up.
Sure.
Be helpful to
Is
have.
the people's real time working?
Yes, it is.
All right, so it must be just yours.
It just wasn't turned on, but
Oh.
I'm not sure how to get it up.
All right. I'll stop talking so you can do that.
Thank you. Did it just shut itself off? Okay, thanks.
Is it working this morning? Okay. Is it working now? Okay, great.
And Your Honor,
Yes,
just on defense instruction 38,
yes.
I neglected to include that in the instructions that we filed with the clerk on Friday, so I'm just going to submit a copy of that to, under the cover of a pleading, just to make sure that the record's complete.
That's fine. Okay, let's start, or let's go on next to the Phase 1 final instructions that I drafted and shared with the parties late on Saturday. I think my staff emailed the parties pretty late on Saturday, a draft of those instructions. And I want to thank both parties for their work on instructions. I know that people submitted all of their proposed instructions a long time ago, and I know that the defense on Friday, at the end of Friday, submitted its proposed, or part of their proposed instructions, including the proposed final instructions for Phase 1. And so I think it makes sense to start there. After I emailed you that draft on Saturday, I changed some things, but the only instructions that were affected are the elemental instruction and the verdict forms. And so I'm going to have my staff distribute to you a new copy of those, and then I'll go through the changes with you, and we can talk about them, okay?
So just to make sure we're on the same page, we also would like to go through the court's introductory instructions as well.
I know. We're going to start with these ones. All right, the record should reflect that my staff has distributed a copy of the elemental instruction as modified after I sent the parties a copy on Saturday, and also a copy of the modified verdict forms. And what we're going to do is we will file this new set as an amended set, and perhaps mark it as, I think it would be C216A probably, C2, because we're going to mark the initial set that I sent you Saturday as C-216, and then we will mark a whole new set, including the modified elemental instruction and the modified verdict forms, C216A. So what I changed in the elemental instruction is the first paragraph, and the change is to specify that the burden of proof that the prosecution has is to prove beyond a reasonable doubt all the elements of at least one alleged aggravating factor with respect to each count of murder in the first degree. So I wanted to make it clear that in order to prove an aggravating factor, the prosecution has to prove all the elements of that aggravating factor. And that point was clear before at the end of the instruction, but it was not clear in that initial paragraph. And so now that has been added. It makes it clear as well that the defendant has no burden of proof. The other thing that changed is in the elements of alleged aggravating factor number 3, created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. I read Dunlap yesterday. This is People versus Dunlap, 975 Pacific 2nd, 723, Colorado Supreme Court, 1999. And in that case, the defendant on appeal brought a vagueness challenge to the grave risk of death aggravator. And the court rejected the the challenge, excuse me. But here's what the court said. We find this argument unpersuasive. The statutory scheme set out in section 16-11-103, which by the way was the statute that was in effect at the time, delineates procedures for imposing sentences for class 1 felonies, and the offense to which subsection 5I, or perhaps it's, 5I I think, aggravator, refers, must therefore be a class 1 felony. The class 1 felonies of which Dunlap was convicted were the murders of Sylvia Crowell, Ben Grant, Colleen O'Connor, and Marge Kohlberg. Although Bobby Stevens was a victim of Dunlap's crimes, he was a victim of attempted murder, which is a class 2 felony. Hence, Stevens was a person in addition to the victims of Dunlap's murder offenses. This interpretation is consistent with the principle that aggravating factors must narrow the class of persons eligible for the death penalty to a subset of murderers who are more culpable than the entire class of murder defendants. Because Dunlap created a great risk of death to Stevens, in addition to killing 4 people, he is more culpable than he would have been had he killed 4 people without also seriously endangering Stevens. And just so that it's clear, in the Dunlap case, Stevens was mentioned as the specific victim in this particular aggravator. So my interpretation of Dunlap is that what I think the way I think we need to phrase this is to have it the way that I've done it, which is that the jury has to find that the defendant, in the commission of the offense of murder in the first degree, knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. So it can't be that in committing the murder in a particular count, the defendant created a grave risk of death to another victim who was murdered. What I infer from Dunlap is that what the court is saying is it has to be one of the victims who was not, it has to be someone who was not a victim of one of the murder counts. So I've changed the language. Both of the parties, by the way, had similar language to each other, but different than what I have. So I changed it. And I don't know if the parties want to be heard on this, but I think this is the appropriate way of doing it. And so I'm disagreeing with what both parties had tendered. Do the people have a position on this particular point?
We have no objection to the way the court has it drafted in this, Your Honor.
Does the defense have a position on this particular point?
We would like a little time to think about it, Your Honor.
Okay, think about it and let me know, but I think this is the right way of doing it. All right, since we're on this, and by the way, so what I did is I changed then the verdict forms consistent with this change, or consistent with that particular change. The other changes, I think, are not substantive and are just as to form. But since we're on this particular instruction now, let's just go ahead and talk about it. So do the people have any objection to the draft elemental instruction? Mr. Orman.
Not, Your Honor.
Does the defense have any objection to my draft elemental instruction? And for the record, the reason why I waited until Saturday to submit a draft of the elemental instructions, or excuse me, of all the instructions, the final instructions for phase 1, was because I wanted to see what the defense would submit. So I wanted to review what the defense would submit and what objections the defense had to what the people had tendered. And so by waiting from Friday, late Friday, when the defense submitted its tendered instructions until the next day, it gave me an opportunity to do that. And I, in fact, made some changes to what I had before I sent the parties my initial draft of the final phase 1 instructions. And I incorporated some of the things that the defense was objecting to in terms of the people's tendered instructions, and also I incorporated some things that the defense's tendered instructions had that I liked, that I thought were appropriate. And you'll see that in terms of the introductory instructions, not the final phase 1 instructions, but the introductory sentencing hearing instructions, which I sent to the parties on Friday, I sent those before I had a chance to review the defense's position on introductory instructions, because I wanted the parties to have an opportunity to review at least my draft of the introductory instructions. You should know that on Saturday, I reviewed those as well, and I have made some changes to my introductory instructions based on the defense's arguments in terms of the people's tendered instructions, and also based on the defense's tendered instructions. And I will give you those and give you a chance to review them during the break, okay? What I did is that I put in bold font all the changes so that you can quickly see them. But back to the elemental instruction in the final set of the phase 1 instructions. Ms. Nelson, any objection to any other part of this particular instruction?
Yes, Your Honor.
Okay, go ahead.
I'd first just like to preface this by saying that we maintain all of the previous positions that we've taken in motions that we filed throughout these proceedings. And so this conversation, and as well as the defense tendered instructions we submitted on Friday are not intended to be an abandonment of any of the issues that we've previously raised in any of our previous motions. And for the purposes of this conversation, we are working within the confines of the court's previous rulings on all of these issues. So I just wanted to start out with that preface.
Well, you're not waiving anything at all, but if there's anything about these instructions that you object to, then I want you to let me know.
Oh, I will.
Because I may not have in mind a specific argument that you made before that I ruled on. So if there's something that you think I need to change or something that you think I need to add, then I'll leave it to you to point that out to me, okay? Please.
Yes, Your Honor.
All
of
right,
course.
you may proceed.
So the first issue I think we need to address, and this actually is an issue throughout the instructions, is this issue that the issue of merger. So in the court's instructions, throughout the court's instructions, it is instructing the jury that it must make these findings with respect to each of the 24 counts of murder in the first degree of which the defendant was convicted. As I think the court could tell, our instruction number 40 instructs the jury that these the 2 counts for each victim merge, the extreme indifference count and the after deliberation count merge into one generic murder conviction for sentencing purposes. I think the law is pretty clear on this. In addition to Candelaria and Lowe, which we relied upon and submitted as a source for our instruction number 40, I also found some capital case law that was on point, namely the Dunlap decision from 2007, as well as People versus Davis, the 1990 Colorado Supreme Court case at 794 P. 2nd 159. So
What's the site in the Dunlap decision?
the Dunlap decision is 173 P. 3rd 1054, and that's Colorado Supreme Court 2007.
Did the court in that case say that the merger happens before the jury deliberates?
Yes, by implication. Both of these, both Dunlap and Davis, involved instructions that were given to the jury. And so it wasn't like the issue of merger wasn't the actual issue in front of the court, but it was an issue with an instruction. So I can just direct the court. In the Dunlap opinion, it was it's at page 1087 to 88. And it was actually an instruction. The issue itself that was raised in Dunlap had to do with a guilt phase instruction, but in the context of discussing that issue, the court addressed this issue of merger. And what the court said was, so in that case, the prosecution had alleged, had pursued 2 different theories of first degree murder after deliberation and then felony murder, and they proceeded on both of those theories. The jury convicted him of both, and then the jury was instructed at the sentencing phase that those 2 merged together. And so it says Dunlap next argued that jury instructions 2 and 13 violated the rule that a defendant can only be convicted of 1 count of first degree murder for a single victim, citing Lowe and Bartoszewski. For each of the 4 murder victims, the jury found Dunlap guilty of both first-degree felony murder and first-degree murder after deliberation. Dunlap argues that those dual guilty verdicts violated Lowe and Bartoszewski. That's Bartowscheski. And the Colorado Supreme Court disagreed with that, and that's not what we're arguing here. Of course, we're arguing that now that they have found him guilty of both, that those 2 counts merge. So in the next paragraph, the Colorado Supreme Court said, Dunlap is correct that he cannot be convicted and sentenced to both first-degree murder after deliberation and felony murder for the death of a single victim. In this case, however, the trial judge entered only 1 conviction for each murder victim, first-degree murder after deliberation, and therefore complied with Lowe. Because only convictions for first-degree murder after deliberation were entered, the trial court did not err in all, and then it goes on to discuss some other convictions, first-degree burglary and aggravated robbery. And it says the jury was instructed at the penalty phase that the first-degree murder after deliberation and first-degree felony murder verdicts merged into a single conviction for each victim, and that they were only to sentence Dunlap on the first-degree murder after deliberation convictions. So I think that makes it pretty clear. Now, of course, Dunlap, the trial itself, this opinion is from 2007, but Dunlap's trial, I think, was in the mid-90s before Candelaria was decided in 2006. And so after Candelaria, I know that the Dunlap opinion, so the Colorado Supreme Court was reviewing what happened at the trial in the context of what the law was at the time. And at the time, I think Lowe was probably the most current case that addressed this issue at the time of Dunlap's actual trial. But I think that may be why the court instructed the jury in that case that when they merged, it merged into after deliberation, the conviction for after deliberation. But I think here and after now that Candelaria is obviously the most recent case on this issue, I think it just merges into one general conviction. So, and then in People versus Davis, which it's at the pin site is 196, so it's 794 p second 159, and then the pin site is 196. The jury also got an instruction on merger. If I can find that, just a moment. So, and again, the actual legal issue is a little bit different, but in the context of addressing that legal issue, the court discussed and addressed the propriety of this instruction that the jury received at the penalty phase of that trial, which was, you are instructed that for the purposes of sentencing, count 1, first degree murder in the first degree after deliberation, and count 2, murder in the first degree felony murder, merge. And the defendant would receive a life sentence on these two counts. And the issue in Davis was whether it was appropriate for the court to tell the jury that, absent any findings that they made, the defendant would receive a life sentence. But clearly, they were instructed that it merges, and the court saw no problem with that. So that's the authority, the specific capital, in addition to Candelaria and Lowe, that's the specific capital authority that we would rely upon. And I can just tell the court, we see a number of constitutional problems if the jury is allowed to deliberate and make findings with respect to 24 counts of first-degree murder instead of 12. We think that would violate Mr. Holmes' rights to due process and a fair and reliable sentencing proceeding. It would also violate the constitutional provision against double jeopardy pursuant to the 5th, 6th, 8th, and 14th Amendments, as well as Colorado Constitution, Article 2, Sections 16, 18, 20, 23, and 25. It's an impermissible doubling up of convictions and aggravators, and requiring the jury to consider and find aggravation 24 times instead of 12 would be prejudicial and would undermine the reliability of a sentence. And I think the other issue, just in a hypothetical world, they could come back with inconsistent verdicts on the aggravators or inconsistent sentences with respect to the two different theories of murder, and that would also create a reliability problem with the verdict. We'd also cite to People versus Durre, D-U-R-R-E, 690 p second 165, Colorado Supreme Court 1984, which is another Colorado case talking about the importance of the reliability of the importance of having a reliable verdict in a capital case.
What's the people's position?
Well, Your Honor, here's what I see. I think that counsel is obviously correct that when you have two different legal theories charged in two different counts of first-degree murder, and a person is convicted of more than one count for a single victim, at the end of the day, when the defendant is actually sentenced, when conviction is actually entered, they merge. But what we're talking about here is not the defendant actually being sentenced or conviction actually being entered. We're talking about a sentencing hearing where the jury makes specific findings. But I think that that term sentenced, as used in these opinions, is referring to the ultimate action that you would take as the judge to impose sentence based on the jury's verdict and enter convictions based on the jury's verdict. And, frankly, Your Honor, whether the jury makes a finding 24 times or 12 times, it makes no great difference to me in the sentencing phase as far as the job they do. The concern that I have is, let's say that the defendant somehow argues down the line that the death penalty should not be allowed for the crime of extreme indifference murder. In other words, let's say the defendant goes to the Supreme Court or the U.S. Supreme Court and says, you've got to limit the death penalty to first-degree murder after deliberation, and that extreme indifference murder should not be a crime that's eligible. Now, I don't think they'd be successful in that, but let's say they make that argument. And let's say that a court in the future says, no, you're right, it only should be for after deliberation. Then what I would see happening is the defense arguing, well, we don't know which they were doing because you all merged it into one, and now he's being sentenced for something he shouldn't get the death penalty for. So I don't see any legal problem created with them making an individualized decision for each count that's charged. They will ultimately merge in the end, obviously, but I think at this point they should make that individual decision. Now, counsel is correct that there could be some inconsistencies. Let's say the jury finds aggravation on one aggravator for one count and not on another, or different ones. But I don't really see that as a very reasonable proposition in this case based on the evidence that we have. So I think that the way the court has drafted these instructions is legally correct, and I would ask that the court's instructions, as they are written, be the ones that go to the jury.
Your Honor, if I may respond briefly.
Hold on. Mr. Orman, let me ask you a question. The statute, and I'm referring to 18-1.3-1201, when it talks about the jury not being able to, or not making certain determinations, it says that the court shall then enter a sentence of life imprisonment without the possibility of parole. It's not as clear in the event that the jury returns a verdict of death, although there is a subsection that says that in the event the jury's verdict is a sentence to death, such verdict shall be binding on the court, which implies that the court then formally enters the sentence that the jury has decided upon. Is that your position, that in the end it's the court that formally enters whatever sentence the jury decides upon?
That is my position, Your Honor, and obviously the court can't disregard the verdict of the jury, but the court is the one that enters the sentence. The court is the one that will sign orders, minimuses, and so forth that go to the Department of Corrections. That's when sentence is entered, I think. So, yes.
Actually, there is one provision that says that if the jury returns a verdict of death, it shall be binding on the court unless the court determines and sets forth in writing the basis and reasons for such determination that the verdict of the jury is clearly erroneous as contrary to the weight of the evidence, in which case the court shall sentence the defendant to life imprisonment. So again, that implies that the formality of the entry of the sentence is something that the court does as opposed to the jury. The jury decides what the sentence is, but that the court formally enters the sentence. All right, Ms. Nelson?
Yes, Your Honor, just briefly to respond. On the first issue, I think even in a non-capital case, in any case, you merge the convictions and then you impose the sentence. You don't decide the sentences and then merge those two sentences. It's clear that the merger happens first, whether it's the court or the jury. This is what we are deciding. It is the sentence, and I think the court is right that it is binding on the court, and it's a jury finding. And so what we're doing here at this penalty phase proceeding is that the jury is tasked with determining sentence. And so that has to be legally, they have to be making the determinations based on the convictions that he will be sentenced to. Otherwise, what we have is the jury imposing sentences that then get merged, and that's not the way that the law works. With respect to Mr. Orman's concern about, someday maybe the death penalty will be found unconstitutional with respect to extreme indifference murder, I don't know if it's in Lowe or Candelaria or another one of the many, many cases that has addressed this issue with respect to non-capital counts in Colorado, but I know that I have seen case law that discusses this exact concern. And, because the same could be true in a non-capital case. They might, sometime in the future, extreme indifference murder could be found to be unconstitutionally vague by the Colorado Supreme Court. And what the case law says is that in that event, because the jury has made these two separate findings when they deliberated, then the extreme indifference murder would, drop away, and you would be left with the after deliberation verdict. So I don't think that's a valid reason for proceeding on all 24 counts.
All right. I think we all agree that merger applies before sentencing is imposed. The sentences are imposed. And the question is the jury imposing the sentences, or if the jury rendering a verdict as to what the sentence should be, and then the court imposes the sentences that the jury decides upon. And my reading of the statute is that it's the latter, not the former. And so I think the merger would occur before the court imposes the sentences decided upon by the jury, and before the court then enters the sentences, and before the court drafts the mitimus and signs the mitimus that will reflect the sentences. And so I think that that's the point where the merger should occur. Frankly, I don't see what prejudice there is to doing it this way as opposed to the other way. In the end, it's the same end result. I think what the law worries about is that the defendant cannot end up with two sentences or two punishments for one conviction, or two convictions for one crime. And that's going to be avoided regardless of whether we do it the way Ms. Nelson is asking us to do it, or whether we do it the way Mr. Orman is asking me to do it. So for now anyway, I'll stick with the way I have it. I'll look further into the case law, but I wasn't able to find anything on point, and I don't think there is anything on point where the merger issue came up in a capital case and this issue was disputed. And so for now, I'm going to stick with the way I'm doing it, but if I change my mind, I'll let you know. Before we go on with this particular instruction, let me just make a record of a couple of things that I should have made a record of. I made a record of the changes that I made to this instruction after I sent it to you on Saturday late in the day. I should make a record that I borrowed from Ms. Nelson's standard instruction in terms of the especially heinous, cruel, or depraved aggravator. And I did that based on People v. District Court, which is cited at 834 Pacific 2nd, 181, and People v. Davis, 794 Pacific 2nd, 159. The District Court case is from the Colorado Supreme Court from 1992. The Davis case is from the Colorado Supreme Court from 1990. And I think based on those cases, I was convinced that I needed to add what I've added to that element or to that aggravator, which is as follows. In order to prove beyond a reasonable doubt that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner as alleged in this aggravator, the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. The tendered instruction from the defense had, in addition to that type of language, had a definition for conscienceless, pitiless, and unnecessarily torturous. But I don't know where those definitions come from, and I looked at the other authority that Ms. Nelson cited, which is Colorado Revised Statute Section 16-8-107, 1B and 1.5B. And as far as I can tell, that's not an authority that has anything to do with this point. So I'm not sure if that was a typo on her part, but those statutory subsections have nothing to do with this issue. So the case law talks about conscienceless and pitiless and unnecessarily torturous, but I don't believe that the cases say that in addition to instructing the jury, as I am intending to instruct the jury now, based on the modified elemental instruction, that I also need to give the definition of conscienceless, pitiless, and unnecessarily torturous. So do the people have a position with respect to this particular change?
I agree with the court, and I think the court should give the instruction the way it is drafted in this instruction that was handed out.
All right, Ms. Nelson, I've given part of the language that you suggested, although you the way you had it in your tender instruction was as follows. In order to satisfy the elements of this aggravator, the prosecution must prove beyond a reasonable doubt that the defendant acted in a manner that was both, 1, conscienceless or pitiless, and 2, unnecessarily torturous to the victim. I see the difference between your proposed instruction just on that point and my proposed instruction as one as to form, not as to substance. And I think mine honors the language from the Supreme Court better, so I'm going to stick with mine. But in terms of the other definitions, I didn't know where those were coming from, and I couldn't find any authority that says that those definitions are either warranted or require, either one. So do you want to address the court about that particular aggravator?
I do. Before I do that, may I just briefly supplement my record with respect to the merger issue and make sure that I've said clearly, if I didn't before, that the prejudice is that it sounds like the jury is sentencing Mr. Holmes for 24 murders instead of 12. And we also would object because the Eighth Amendment and Colorado Constitution Article 2, Section 20 requires heightened reliability in a capital case. And we would also rely on Ring versus Arizona for the proposition that the jury is, in fact, imposing the sentence, and that is the entire purpose of the sentencing proceeding here.
Well, given that the jury was told that there are 24 counts, and the jury understands that there are 2 theories for each count, I don't see much of a concern. But you've made your record now. In terms of this particular aggravator, what's your position?
Well, just so the court knows, the reference at the very end underneath our sources to 16.8.107 1B, that actually I should have removed that. I had something else in there that I ended up taking out, so that was a typo. Okay. But just so the court knows, the definitions came from that People versus District Court case from 1992. It was the Alan Thomas case, and it was just between, I think it was 1988 and 1991, the Colorado legislature did include specific definitions for these terms in the statute, and then those were later removed. And those definitions are contained within that People versus District Court opinion. So that's where I got them from, just so the court knows. But I don't have any additional argument on that other than to say I think that I would ask the court to give it the way that we've requested and separate out 1, conscienceless or pitiless, and 2, unnecessarily torturous to the victim, just so that it's clear that they have to make 2 separate findings.
All right. In terms of the last point, as I said, I'm going to stick to the way that I have it formatted, because I think it honors the language from the Supreme Court. And secondly, in terms of the definitions, People versus District Court did discuss the definitions, but it was in talking about or explaining the statutory definitions that used to exist. They no longer are in existence. In fact, by the time People versus District Court was decided, I believe they were no longer in the books. And the court wasn't saying, look, we think these terms need to be defined as well, even though the legislature has now done away with the definitions. So just because the court included the definitions that used to be statutory definitions doesn't mean that the jury should be instructed on them. The court was simply explaining the history of the aggravator. And so for those reasons, I think the instruction should not include those particular definitions. The next one I have is, the record that I want to make is in terms of lying in wait and ambush, that aggravator. I looked it up to see whether a definition was appropriate or necessary, and People versus Dunlap, 975 Pacific 2nd, 723, Colorado Supreme Court, 1999, resolved that issue and said no. Those are terms that lay people can understand. Those are terms that have a common and plain meaning, and they do not need a definition. The next record I wanted to make with respect to this elemental instruction is about the terms extreme indifference and grave risk of death. Extreme indifference does not need a definition. That's under People versus Esparza Treto, T-R-E-T-O. Esparza is E-S-P-A-R-Z-A, 282 Pacific 3rd, 471. That's a Colorado Court of Appeals case from 2011. And grave risk of death, Dunlap addressed, and we've talked about that one already. And I think that Esparza Treto may have also addressed grave risk of death, and the case law in Colorado reflects that it's a common term with a plain meaning that lay people understand, and so that doesn't need to be defined.
To interrupt,
Yeah.
our real time has stopped working, and I just wanted to make sure I got those citations from the court.
Okay, Esparza Treto is 282 Pacific 3rd, 471, Colorado Court of Appeals case from 2011. And People versus Dunlap, it's the one that I have cited before, 975 Pacific 2nd, 723.
Are we the only ones again?
Mine has stopped as well, so we'll just go forward. Maybe during the break we can call Ms. Martin and see if she can look into it.
Cases, Your Honor, were with respect to the issue of not defining extreme indifference, is that right?
I believe so. Extreme indifference was Esparza Treto, and I think Esparza Treto also addressed grave risk of death, but I know that Dunlap addressed grave risk of death because I have discussed it already. So I don't believe either one of those terms needs to be defined, and neither party is asking me to define either one of those terms. I just wanted to make a record of that. And the other one was universal malice. And we talked about universal malice during the guilt phase instructions. The defense asked me not to define that term. That term is not defined by any statute. It is defined by the case law. I did not provide a definition for the jury because neither side was asking me to do so, and the defense was specifically asking that I not do so. And I'm assuming it's the same position at this time. Is that right, Mr. Orman?
Yes, Your Honor.
Is that right, Ms. Nelson?
Yes, Your Honor.
All right, back to the elemental instruction then, or still staying with the elemental instruction, I should say. Ms. Nelson, what else do you want to talk about with respect to this particular instruction?
Before I forget, I want to make sure that we maintain our objections to all of the aggravators that were raised in motions D-158, D-159, D-160, D-161, and D-162.
Again, you're not waiving anything, so I don't know, I don't think you need to repeat that. But if there is something that you need to have me address now, now is the time to ask me. I don't have those rulings in front of me. So if there's something in the instructions that you're objecting to, you need to make a specific record of that now. So is there anything else in this particular instruction that you would like to talk about?
Yes.
Go ahead.
So this applies actually to all of the aggravators. Well, first we would ask that the court break out the aggravators into separate instructions instead of including them all in one instruction. I think that's easier for the jury to read. And also under Ring versus Arizona, these aggravators are functional equivalents of an element of the offense, and I think they each needed to be treated separately by the jury. And so our request would be to make them separate, each and every one of them separate instructions.
I think that's confusing because the people don't have to prove all the aggravators. They only have to prove one, at least one. And if you set them aside so that each one of them has a separate instruction, then it gets confusing. I noticed that in one of your tendered instructions, and perhaps more than one, you actually misstated the burden of proof. You said that the prosecution has to prove all of the aggravators or each aggravator. That's not accurate. Mr. Orman, do the people have a position?
Your Honor, my position is that the instruction should be given the way the court has drafted it.
Yeah, I like it better the way I have it, Ms. Nelson, so I'm going to stick with my format. What else?
We would ask that the court consider including, so I've numbered the court's pages for my own reference, but we would ask that the court consider including the two paragraphs at the very end of the instruction that state, after considering all the evidence, if you decide the prosecution is proven beyond a reasonable doubt, each of the elements of an alleged aggravating factor, et cetera, we would ask that the court include that language after the definition of each aggravator.
Yeah, again, I think that's unnecessary. It makes the point at the end. I'm saying it at the beginning of the instruction. I'm saying it again at the end of the instruction. I'm saying it elsewhere in these instructions. It is repeated multiple times that the burden of proof on the people is to prove beyond a reasonable doubt at least one of the aggravators the people have alleged. And that in order to prove an aggravator, the people have to prove all of the elements of the aggravator beyond a reasonable doubt. So that is very clear from these instructions, and I don't think that's necessary. What else?
The next concern we have, Your Honor, is just the shorthand terminology that the court has included at the beginning of each aggravator. So it says the elements of alleged aggravating factor number 1, killed 2 or more people are, and then lists the aggravators, and then it goes on to do that in each count. We actually included some shorthand in our verdict form as well, but after thinking about it a little bit over the weekend, we've concluded it's problematic and it's also not necessary. So the shorthand for some of these, like killed 2 or more people, well, there's a mental state that goes along with that that's not included in the shorthand. And the same thing for the killing of a child under 12. And so we would just ask that the court delete those shorthand titles. It's going to be very clear what those aggravators are after the court reads the elements. And so we would ask that the court just simply state the elements of alleged aggravating factor number 1 are, and then list the aggravators, and then do the same for the remaining 4.
I thought about doing that, and I was about to do that, and then I noticed that your number factors and their number factors are different. And that's the problem. Then you get confused and you have an unclear record.
Well,
what if you two can't agree on which is number 1, number 2, number 3, and number 4, number 5, then it's difficult. And the benefit of having some kind of descriptor is that it at least avoids any confusion. Well, which one was number 1 again? Which one was number 2 again? It's just an easy reference, and it's an easy way to quickly know what aggravator we're talking about. So if you want, I can modify them so that instead of saying kill 2 or more people, they could read 2 or more people. The other one could read a child under 12 years of age. The next one could read a grave risk of death, and we could leave it at that. The next one could read, especially heinous, cruel, or depraved manner. I don't think there's much we can do about that one. And the last one, lying in wait or from ambush, I think that's probably as short as it can get. I just have a concern about simply referring to them by number, because I think it lends itself to confusion and to lack of clarity in the record. So if you have other suggestions, I'm open to them. I just don't want to refer to them simply by number. And the truth is, we sort of do it with the elemental instructions that we do for charges. You know, we refer sometimes to count one, murder in the first degree after deliberation. We don't say count one, which charges the defendant with murder in the first degree. It's understood. And I have added the word alleged throughout for that reason, to avoid any prejudice as well. So it says the elements of alleged aggravating factor number one, and then it would read two or more people, and then it would say are, and then it would have the elements. That's an example. But I have used alleged throughout the instructions, even though the parties I don't think have done that. I think it's appropriate to do that.
My biggest concern is with the second aggravating factor, killed a child under 12 years of age, because there is a very important mental state. It's intentionally killed a child under 12 years of age. So if the court is going to keep any shorthand titles, we would ask that the court add the word intentionally to that title, because otherwise the jury may just assume that that aggravator has been established simply because a child died.
You prefer that to just having a child under 12 years of age?
Yes.
Okay. I think that's an appropriate suggestion, so I will add it. So it'll say intentionally. But that means that to be consistent, I should add it to the other ones as well. So is that okay with you, Ms. Nelson?
Well, I think the first one, killed two or more people, the court should include intentionally, knowingly. I mean, that gets complicated. But the others don't. There are some that don't have the mental state of intentionally. So that's a specific request with the child under 12 aggravator.
Well, I'm happy to change the title on the first one to read intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed two or more people. But if you're fine with just leaving killed two or more people, then I'll leave it like that. So you tell me.
We're okay with leaving the first one, two or more people, as the court had
Okay, that's fine.
about the killed part.
All right, what about the third one? Created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree.
Your Honor.
Yes.
We don't have a strong position on the others.
Okay, we'll leave the other ones as they are then. All right. What else, Ms. Nelson?
On the page that addresses the killing of a child under 12,
Yes.
consistent with our argument on merger, we would ask the court to amend the language stating that aggravating factor number 2 is only alleged with respect to the conviction pertaining to Veronica Mosier Sullivan instead of counts 9 and 21.
Okay. I'll stand by my ruling for now, and if I do additional research and find that I should change it, I will. But given my ruling on the issue of merger, we'll keep it the way it is.
And then finally, we would ask, with respect to the heinous, cruel, and depraved aggravator and the lying in wait aggravator, the way that we submitted the elementals, I think we broke out element B into two separate elements. So it would be committed the offense of murder in the first degree, and then a separate element in an especially heinous, cruel, or depraved manner. And then same thing for the lying in wait aggravator. We separated out the lying in wait part from committed the offense.
I noticed that, but in this case, the jury has already found that he committed the offense of murder in the first degree with respect to this count. So I didn't see the point in breaking that out. I think what is different, or what's new from the prior proceedings, is that they have to find that it was in a especially heinous, cruel, or depraved manner. And I thought that it made sense to keep it all in one. I thought that it was clearer that way, and I thought that it was easier to follow and understand that way. Do the people have a position on this?
Not really, Your Honor. I prefer the way Your Honor has done it, and that makes a lot of sense to me.
You know, to be consistent with the other the other elements of, or the elements of the other aggravators, I'll go ahead and break it into two. So I'll grant the request. I don't really think it makes a difference. I mean, either way, we're saying the same thing, but I think to be consistent, we'll do that. So, Ms. Nelson, that's what you're asking me to do, right? So the elements of alleged aggravating factor number 4, especially heinous, cruel, or depraved manner, would read as follows. A, that the defendant, B, committed the offense of murder in the first degree, C, in an especially heinous, cruel, or depraved manner. And the elements of alleged aggravating at factor number 5, lying in wait or from ambush, would read as follows. A, that the defendant, and that should read that the defendant, so I'll change that. B, committed the offense of murder in the first degree. C, while lying in wait or from ambush. Correct?
Yes.
Okay, that's how we'll do it. What else?
And then just upon reflection, the court's change to the grave risk of death aggravator, we object to the change. We think that the court needs to include the language exactly as the way the prosecution pled it and exactly as it is stated in the statute. So that's our position on that.
All right, let me go back to that. Well, if I take it back to the way that you both tendered that elemental section of the instruction, then it's possible that the jury could find that the defendant created a grave risk of death to someone else who was murdered. And the Dunlap opinion seems to be saying that it has to be someone who wasn't a victim of a murder. And in Dunlap, there were 4 victims who were killed. And the court specifically indicated that the other victim that this aggravator was referring to was someone who was the victim of an attempted murder. And the court relied on that for finding that the aggravator was not unconstitutionally broad. So that's my concern. So do you read Dunlap differently?
For the factual that was the court's interpretation in Dunlap, but I don't read Dunlap to say that that's the way that the instruction has to be given to the jury.
Mr. Orman?
Well, I can't imagine how the defendant would be prejudiced by the way the court has drafted this. In fact, it limits the possibility of what the jury could find on this. It decreases the universe of possible people that for whom a grave risk of death to another person could be found. So, and in considering the language in Dunlap, I agree with the way the court has it, and I would ask the court to give it the way it is drafted here.
Hold on. The way Dunlap defined the term offense as used in this aggravator is that it refers to a class one felony. And that's why the court was saying, well, in this case, there was no problem because the court specifically said that the person that this aggravated, the person other than the victim that was being referred to was this Bobby Stevens, who was a victim of an attempted murder, not a victim of a class one felony murder. And that's my concern with leaving the language the way both parties had it. So given the language in Dunlap and given the discussion, I'm going to leave it as I indicated that I would, which is as I have it right now in the amended format, in the amended instructions. Okay, what else, Ms. Nelson?
I think that's it with respect to that instruction, Your Honor.
All right. Then let's go to the beginning and let's make our way through the instructions. And if you've read through them, then you know that there may be some instructions that you tender that are not instructions in my set, but the concepts in those tendered instructions are incorporated into some of the instructions that I have in my set. So let's go through them. The first one is the one that starts with members of the jury. Phase one of the sentencing hearing has been completed, and then it goes from there. Do the people have any objections to this instruction?
No, Your Honor.
Does the defense have any objections to this instruction?
Our only request with respect to that instruction is we would ask the court to consider deleting in the second paragraph on the first page. Please do not draw any inferences from my decision to use these terms. The only reason I use these terms is to avoid confusion. As I discussed both proceedings, it would have been just as appropriate for me to refer to the two proceedings as the first trial and the second trial, or the guilt trial and the sentencing trial.
Yes.
We think it's appropriate for the court to refer to the proceedings as the trial and then the present part of the proceedings as the sentencing hearing. And we don't think that the court needs to draw any more attention to it than that. And we would just ask the court delete the rest, keep the first sentence and delete the rest of the paragraph. And it, consistent with some previous objections that we've raised to the guilt trial, we don't like drawing the jury's attention to that term, and we don't think it's necessary. So we would just ask that the court delete the rest of that paragraph.
I was doing it for your benefit because you both have referred to the first part as the first trial and the second part as the second trial, or the first part as the guilt trial and the second part as the sentencing trial. Remember that we've been talking to these folks, some of them since January, not for the first time they came in for jury selection, and we've used different terms. So if you want me to take it out, I'm happy to take it out. So if you want to just leave the first sentence, that's fine with me. I was doing it for your benefit. I'm also happy to just take out the guilt trial and the sentencing trial if that's what bothers you, although at this point, I mean, I don't know what the concern would be about that. So, but Ms. Nelson, if you're asking me to just leave the first sentence, I'll do that.
Thank you, Your Honor.
Okay, that's what I'll do. Okay, what else?
That instruction.
Okay, the next instruction is the one that starts with, you are instructed that in determining whether the prosecution has met its burden of proof in phase one of the sentencing hearing, you are to give separate and individual consideration to each alleged aggravating factor with respect to each count of murder in the first degree. And I incorporated some of the concepts in the defense's instruction in this one, but we'll start with the people. Mr. Orman, do the people have any objection to this particular instruction?
Your Honor.
All right, does the defense have any objection to this instruction?
Yes, Your Honor. Just, again, on the same topic of merger, we would ask the court to change each reference to count of murder in the first degree to conviction, because our position is that the two counts for each victim merge into one conviction. And then at the bottom of that first page, it would say, based upon your earlier verdicts, the defendant has been convicted of, or has received 12 convictions for murder in the first degree.
I've tried to avoid using the word convicted because it's a term of art under the law and it has a specific definition. In terms of the merger issue, I've ruled on it for now. If I change my mind, I'll let you know. But what I will do is, instead of saying has been convicted, I'll say the defendant has been found guilty of 24 counts of murder in the first degree. What else?
And then on the next page, it's the last sentence of the instruction where it says your phase 1 sentencing verdict with respect to each count must be unanimous. I think the law recognizes non-unanimous verdicts at sentencing, and so I think perhaps it would be correct to state, instead of each count, each aggravator, or perhaps if the court was intending to say, right, sorry, I'm just looking at my notes. Before finding the existence of any particular aggravator, the jury must be unanimously convinced beyond a reasonable doubt that the prosecution has proven that particular aggravator at issue.
Well, the sentencing verdict with respect to each count refers to the jury finding that either the that it is unanimously finding the prosecution has proven beyond a reasonable doubt at least one aggravating factor, or that it is not unanimously finding that. Do the people have a position?
Well, not really, Your Honor, although frankly, I don't mind the suggestion that Ms. Nelson had regarding this sentence.
Or what if I just delete that last sentence, Ms. Nelson?
Moment then to see how that would read.
Yes.
Just thinking about that, I think we do need the word unanimous in there somewhere, and I
Okay.
don't think we can take that out.
All right, so how would you?
I mean, I think you
Trace
could
it.
include unanimously in between. It could say you must unanimously decide whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor.
I don't know that takes care of it. You must unanimously decide whether. That still doesn't seem to take care of it.
And I would propose adding removing that last sentence and then adding a sentence that says, before finding the existence of any particular aggravator on any particular conviction, the jury must unanimously agree that the prosecution has proven that aggravator beyond a reasonable doubt.
Okay, say it slower for me because we don't have
Real time.
real time, please.
Sure. Before finding
Right.
the existence of any particular aggravator on any particular conviction, or with respect to any particular conviction, the jury must unanimously agree that the prosecution has proven that aggravator beyond a reasonable doubt with respect to that conviction. I don't know if you need that last with respect to that conviction. I may have said that twice.
All right. I'll modify what you just suggested a little bit. It would read as follows. Before finding the existence of any alleged aggravator with respect to any count, the jury must unanimously agree that the prosecution has proven beyond a reasonable doubt that aggravator.
I think it should say aggravating factor, not aggravator, which is the way it's referred to elsewhere. But if, with that change made, Your Honor, I don't object to that.
Okay. All right, I'll change. I think I agree with Mr. Orman that we should be consistent. All right, let's go to the next one. The next one is the one that starts with, you shall presume that each aggravating factor alleged by the prosecution with respect to each count of murder in the first degree does not exist unless you unanimously find that the prosecution has proven beyond a reasonable doubt the existence of an alleged aggravating factor with respect to any count. And then it goes from there. Do the people have a position on this one, Mr. Orman?
We don't object.
All right, Ms. Nelson?
With that first sentence is that it makes it sound like the presumption goes away once any aggravator is found. So we would ask the court to rephrase that. With respect to each conviction, you shall presume that each aggravating factor alleged by the prosecution does not exist unless you unanimously find that the prosecution has proven beyond a reasonable doubt the existence of that alleged aggravating factor as it pertains to that particular conviction. And that would take care of our concerns.
Actually, I don't even think we need as it pertains to that count at the end. I think it takes care of it before. What about this? With respect to each count of murder in the first degree, you shall presume that each aggravating factor alleged by the prosecution does not exist unless you unanimously find that the prosecution has proven beyond a reasonable doubt the existence of that alleged aggravating factor.
That's fine with us, Your Honor.
Okay, great. Anything else?
Again, with the 24 counts, our position is that it should be 12 convictions.
Right. What
And
else?
And then our request would be to make, reasonable doubt is obviously a very important concept throughout these proceedings, and we would ask that the court make the reasonable doubt instruction contained at the end of that instruction as a standalone instruction.
Yeah, I put it at the end because it sort of mirrors the way that the guilt phase instructions do it, but I don't have a strong preference one way or the other. Do the people have a position on this?
No, it's not.
All right, I'll make it a separate instruction at the defense's request. All right, the next one starts with, you are instructed that the fact that the prosecution seeks a death penalty in this case is entitled to no weight whatsoever in your decisions in phase one of the sentencing hearing. Any objection from the people, Mr. Orman?
No, Your Honor.
Any objection from you, Ms. Nelson?
No, Your Honor.
The next one starts with, the fact that the prosecution has alleged that aggravating factors exist in this case is not evidence. Any objection to this one, Mr. Orman?
No, Your Honor.
Any objection to this one, Ms. Nelson?
No.
The next one starts with, the defendant has asserted his right to be sentenced by a juror. No juror should allow himself or herself to be prejudiced against the defendant in any way because of the defendant's assertion of his constitutional right to sentencing by a jury. My recollection, Ms. Nelson, is that you had opposed the people's standard instruction a little bit. I think in general, what you had said is that you didn't have an objection in general to the people's proposed instruction, but that you prefer yours. And I couldn't find one that you tendered along the lines of what this instruction says. But first, let me ask the people, do you have an objection to this particular instruction?
No, Your Honor.
All right, Ms. Nelson, I may have missed it, or I may have misunderstood your comment, but that's what I thought you were saying with respect to this instruction.
And, you know, I honestly, without looking through the people's proposed instructions, I can't tell you. I don't remember if they proposed an instruction like this. I know that I made a similar comment with respect to the proposed instruction about the right not to testify, but we would object to this instruction being given at all. we think that it suggests that Mr. Holmes has done something, he's made some sort of separate request to be sentenced by a jury when in fact, if he didn't want to be sentenced by a jury, there would be a complicated waiver process that we would have to go through. So we object to this instruction being given. We ask that it not be given.
And I may not have included it if I had thought that you objected to it.
And if I said something inconsistent on Friday when I submitted our comments to the prosecution's instructions, then I apologize. I think that we came to this conclusion after reviewing the court's instructions over the weekend. So.
Okay, Mr. Orman.
I think it's for the defendant's benefit, this instruction. If they object to it, they don't want it. I don't think the court needs to give it, so.
Okay,
that's my
I
position.
agree. I won't give it, but the record should reflect that the reason I'm not giving it is because the defense is specifically asking me that I not give it. All right, the next one I have is, in reaching your phase one sentencing verdicts, you may consider any evidence that was presented during the trial with one exception. You may not consider any evidence that was admitted during the trial solely for your consideration of the issues raised by the defendant's plea of not guilty by reason of insanity. Additionally, the court reminds you that during the trial, it admitted other evidence for a limited purpose. You may consider such evidence in making your decisions in phase one of the sentencing hearing only for the limited purpose I told you about when it was admitted. And I have emphasized the word other, as in other evidence, by making it bold font. And this was one that I drafted based on what I read in the defense's objections to the people tender instructions. Mr. Orman, do the people have any objection to this instruction?
We don't, Your Honor. I am trying to think of what that other evidence is, and nothing is popping to mind right away.
There was, for example, there were some emails that were admitted, and I told the jury that to the extent that there were statements by someone other than the defendant, that they were only being admitted to make the defendant's statements intelligible and to place them in context. So,
Thank you for refreshing my memory, Your Honor. That is absolutely correct. I do not object to this instruction.
okay, and there may have I think there was other evidence along those lines too. For example, there was evidence that I admitted that I told the jury it was not hearsay because it was being admitted for something other than the truth of the matter asserted, and so this was the best I could do. But I think it's an accurate instruction and a complete instruction. Ms. Nelson, does the defense have an objection?
To this instruction, Your Honor, no.
Okay, great. And thank you for pointing that out in your comments, because that's what brought it to my attention. I appreciate you doing that. And let me just say, I very much appreciate all the hard work that both sides have done on instructions. It makes my job a lot easier. I know that you've worked on them. Ms. Nelson, I know that not only did you tender your own instructions, but then at my request, you actually submitted specific comments to the people's tendered instructions, which was very helpful to me. So I very much appreciate you doing that. All right, the next one starts out with, regarding the evidence admitted during the trial that you may consider in reaching your phase one sentencing verdicts, the court reminds you that a fact may be proven by either direct or circumstantial evidence. Let me just say that with respect to the next few instructions, that they are instructions from the guilt phase of the trial, or the first part of the trial, with the proceedings that we just finished. And I thought that it made sense to include the initial phrase regarding the evidence admitted during the trial that you may consider in reaching your phase one sentencing verdicts. The court reminds you that, and then it goes on from there. I just want to make sure that the jury understands why we're giving the instruction. I think that people had included these instructions without that phrase, that introductory phrase. I think Ms. Nelson had indicated, I don't think it's necessary because neither side is intending to present any evidence in phase one. And then I was concerned the jury would be confused. Why are they giving us this instruction? There was no evidence presented. Well, I think the reason we have to give it is because the jury can still consider the evidence that was admitted during the trial. And as long as that's the case, and I think we need to give it and then just sort of explain to them with the introductory phrase why we're giving it to them now. So, Mr. Orman, do the people have any objection to this instruction?
I don't, Your Honor. The only comment I would have is it seems to be something going on with the formatting on that first paragraph, especially the left justification.
Okay, I'll check that out. Thank you. I wanted to get this out to you on Saturday, and so I may have screwed up the justification. All right, Ms. Nelson,
We don't have anything additional, Your Honor. We just maintain that we don't think it's necessary.
the justification doesn't bother you?
I did notice that as well.
Okay. All right, the next one is regarding the evidence admitted during the trial that you may consider in reaching your phase one sentencing verdicts. The court reminds you that the number of witnesses testifying for or against a certain fact during the trial does not by itself prove or disprove that fact. By the way, the previous instruction went on to talk about direct or circumstantial evidence, just so that the record is clear. Any objection to this instruction about the number of witnesses testifying for or against a certain fact, Mr. Orman?
No, Your Honor.
Ms. Nelson?
I think it's necessary, but if the court is going to give it, it looks like there is a small typo on the second line. It should read, the court reminds you that the number of witnesses.
Thank you for catching that. Yes, I appreciate you letting me know. I will make that correction. The next one is regarding the evidence admitted during the trial that you may consider in reaching phase one sentencing verdicts. The court reminds you that you are the sole judges of the credibility of each witness who testified during the trial and the weight to be given to each witness's testimony. Any objection from the people?
None, Your Honor.
Any objection from the defense? The next instruction reads as follows, at least the beginning of it. Regarding the evidence admitted during the trial that you may consider in reaching your phase one sentencing verdicts, the court reminds you that you're not bound by the testimony of witnesses who testified as experts during the trial. The credibility of an expert. Any objection to this instruction, Ms. Nelson?
We maintain our position that this one is not needed either, and our particular concern with this instruction is that so many of, not all, certainly there were other types of experts who testified during the trial, but many of the experts who testified at the trial testified as to issues pertaining to Mr. Holmes' sanity that the jury's not allowed to consider. So that's our concern with giving that instruction.
May I respond?
Yes.
I understand what counsel's saying, but the specific experts that I think would really pertain to this would be Brent Mills and Dale Higashi, who testified as to the firearms, the ballistics, and so forth, and for the risk of death to another, and I think for the extreme indifference in the other instruction. That expert testimony applies to what the jury can consider in this phase. So I think that they need to get the instruction on expert witnesses.
All right, and I'm giving them the other one that specifically tells them that they are not to consider any evidence that was admitted for the limited purpose of the issues raised by the not guilty by reason of insanity plea. And of course, counsel can remind the jurors about that during their argument. So if you want, I'm happy to remind them again about that in this instruction, Ms. Nelson. I don't have a problem doing that. I don't think it's necessary because I'm already telling them that, but I do think I have to give this instruction, so.
And we would ask that the court then consider modifying the instruction just to make it clear which experts, make it clear the experts that testified about Mr. Holmes' sanity and that they're not permitted to consider that as aggravation. Or perhaps including a line at the beginning saying, to the extent that you are permitted to consider, reminding the jury about the limitations on their consideration of the evidence from the first trial, and then stating something like, to the extent that you may consider testimony of experts from the first trial, you're instructed that the court reminds you that you're not bound by the testimony of witnesses, etc.
How about if I do this, Ms. Nelson? Regarding the evidence admitted during the trial that you may consider in reaching your phase one sentencing verdicts, which does not include evidence admitted solely for your consideration of the issues raised by the plea of not guilty by reason of insanity. And that phrase that I just added with which does not could be in parentheses, and then it would say the court reminds you that you're not bound by the testimony of witnesses who testified as experts during the trial, and it would go on from there. Would that take care of it?
Yes, Your Honor.
Okay, I'll do that. All right, the next one, this is the one that talks about the defendant's constitutional right not to testify. Frankly, I looked at the people's, I looked at the defenses and instructions, and then I drafted my own. I think I did I think it's even more generous to the defendant, if you will, but if you want me to use yours instead, Ms. Nelson, I'm happy to do it. Do the people have an objection to this one?
I don't, Your Honor. It does bring up in mind just the idea that the defendant will need a courtesy advisement for phase one. I think a separate one, and probably a separate one for phase two and phase three if we get there, and then there's probably an allocution advisement that needs to be given as well. But I think we can cross that bridge when we get to it. I just thought I would mention it. That brings that to mind.
Yes, and I want to talk to you folks about that, because if there's not going to be any evidence presented, and it sounds like neither side is intending to introduce any evidence, then I will have to give the courtesy advisement before we bring the jury in on Wednesday. So, and then any allocution advisement, I'll ask the parties to submit something to for the court's review so that I can give that advisement. All right? So, Ms. Nelson, do you have any objection to this instruction?
Just a moment, Your Honor.
Yes.
One modification
Yes.
we would request, which would just be to end that last sentence after aggravating factor. It's a little bit long.
Okay.
And change "and" to "any," so cannot be used as a reason to find that the prosecution has proven any alleged aggravating factor, period.
Okay, I'll make those changes. All right, the next one we've talked about, that's the elemental instruction, so we can skip it now. That brings us to the one that starts with certain words and phrases used in the aggravating factors alleged have particular meanings, and it goes from there. And really the only difference, or the main difference that I saw between the tendered instructions from the parties, was that the people use words and phrases, and I think the defense used mental state or state of mind. And I had some concerns about using state of mind or mental state, and I thought it was more appropriate to use words or phrases. Do the people have any objection to this instruction?
No, Your Honor.
Does the defense, Ms. Nelson?
The only record I would make is that we raised an objection to a similar instruction at the merits phase conference regarding that sentence, "It is immaterial whether or not the result actually occurred," and we would just maintain that objection. But otherwise, we don't have any additional objections to the instruction.
All right, thank you. And that's part of the definition of intentionally or with intent, so that will stay in there. That's a statutory definition. The next one is about submitting written questions to witnesses during the trial, and I thought it was appropriate to give it even because it's referring to during the trial. Any objection from the people?
None, Your Honor.
Any objection from you, Ms. Nelson? No. The next one has to do with note-taking. I did not include this one in the instructions that I gave at the end of the trial, but I did give it orally. I've given it a couple of times orally. I gave it at the beginning before opening statements, and I gave it at the end right before closing arguments. One of you submitted it or included it in your tender instructions, and I didn't see any harm in adding it. Any objection from the people?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
The next one has to do with, once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of the bailiffs who will bring it to me. This is the same one that we use at the end of trials, and I think it's appropriate here. Any objection from the people?
None, Your Honor.
Any objection from the defendant?
No, Your Honor.
And then the next one is the last instruction, which talks about the verdict forms. And it starts with, following the attorney's arguments at the end of phase one of the sentencing hearing, the bailiffs will escort you to the jury room so that you may deliberate. I have drafted sentencing hearing phase one verdict forms, and I've included a couple of sample forms for the parties, one for count one, and the other one is for, I believe, count 9. Yes, and each of my verdict forms has two parts, Part A and Part B. And I know that this is a little different than what the parties submitted. I will make the changes to Part B consistent with the changes that I made in the elemental instructions in terms of the title to aggravating factor number 1. It will read intentionally, or actually was it not number 1, it was number 2, intentionally killed a child under 12 years of age. Let me see if there were any other changes that I had to make based on the changes to the elemental instructions, or to the elemental instruction, I should say. I think that's the only one. All right, do the people have a position on the last instruction and the verdict forms?
I think that the court's instruction and verdict forms are correct and should be given as the court has provided them.
All right, Ms. Nelson, any objection from you?
Couple of things, and then if I can just have a moment to confer with my colleagues about one additional thing. The first would just be the objection to the 24 verdict forms and references to counts instead of convictions that
Okay.
relates to the merger issue. Second is that on the second page of this last instruction, it looks like there's a typo in the middle of that first paragraph or towards the end where it says "in that event."
Oh, yes, I see it. Thank you. I will take out that period. Actually, it's repeated, so I will fix that.
And then, again, on the verdict form, we would object to having count 1 and then murder in the first degree after deliberation, consistent with our arguments on the merger. It should just say conviction and shouldn't reference, it should be merged pursuant to Candelaria into one general conviction for first degree murder. And then if I may just have a moment to confer with my colleagues about one
Yes.
other issue.
Yes, you bet.
So one other issue, Your Honor, that pertains both to this last instruction as well as to the verdict forms. On the second page of the instruction, in the last sentence of the first paragraph, in that event, the jury will render a sentencing verdict of life imprisonment without the possibility of parole on that count. We would ask the court just rephrase that to state, in that event, Mr. Holmes will be sentenced to life without parole on that conviction. And then, along with that, we would ask the court to make a similar change on the verdict form under subsection 2 of Part A. The sentence at the end of that subsection that says, therefore, we, the jury, render a sentencing verdict of life without parole. We would ask the court to omit that, and then instead, in the section with the double asterisk, include a final sentence that just says, Mr. Holmes will receive a sentence of life without parole.
I did it based on 18-1.3-1201, and it is subsection 2B, small b, Roman numeral 1. It says, in the event that no aggravating factors are found to exist, as enumerated in subsection 5 of this section, the jury shall render a verdict of life imprisonment, and the court shall sentence the defendant to life imprisonment. So I was trying to to follow the statute and track the language in the statute. Do the people have a position on the last request, Mr. Orman?
I think the way the court has done it is more appropriate.
I do as well, so I'm going to leave it the way it is. That last request is denied. All right, are there any other instructions that the people want to tender in terms of the final Phase 1 sentencing hearing instructions, Mr. Orman?
Not regarding Phase 1, Your Honor, no.
All right, any other final Phase 1 instructions that the defense wants to tender? Ms. Nelson?
May I have just a moment, Your Honor?
Yes. Or anything else that we should talk about. You should not assume that I have rejected something that you thought needed to be included that is not included. It's possible that I missed it, given how many instructions I'm dealing with. I've got the people's standard instructions, I've got your tender instructions, Ms. Nelson, and I got Ms. Nelson's comments with respect to the people's standard instructions, and then I've got my draft, and so it's very possible that I may have missed something. So if there's something that you had included in your tendered instructions that you think I've left out that we should talk about, let me know.
I think that will pertain more to the introductory instructions than these. I don't think that we have anything else to add, except, did the court say it is going to amend the verdict form with respect to the shorthand descriptions of the aggravators?
Yes, just number 2, right? You said the other ones you were okay with.
I think the first one, didn't we agree to take out killed? And just have it read 2 or more people?
I
think that was,
okay.
if we didn't make that clear, that's our request.
Yeah, I may not have understood that. Okay, that is done.
And then, along the same lines as, I just want to make sure I preserve this, going back to, it's the 9th page of the instructions that the court sent to us over the weekend. It's the instruction that begins, you shall presume that each aggravating factor alleged by the prosecution. It's the second page of that instruction.
Oh, okay.
It's just a similar objection. It's the same objection that we just raised with respect to the verdict form in that last instruction, where it says the jury will render, it's on the second page of that instruction, the jury will render a sentencing verdict of life imprisonment without parole on that count. We would just ask the court to rephrase it, stating that Mr. Holmes will receive a sentence of life imprisonment without parole on that count.
So that was the same objection that was made with respect to the last instruction in the verdict forms, and it's the same ruling.
And lastly, I think we made this request with respect to the merits phase instructions, but we would request that he be referred to as Mr. Holmes instead of the defendant, and we make that request pursuant to the 8th Amendment, as well as Colorado Constitution, Article 2, Section 20, and heightened reliability required in capital cases, and the fact that Mr. Holmes is to be treated as a uniquely individual human being under the case law of the United States Supreme Court.
well, consistent with the initial instructions, and consistent with the model instructions, I'll refer to him as the defendant. Is there anything else then with respect to the final Phase 1 instructions? I will make the changes that, the record should reflect that both parties were silent when I asked that question. I will make the changes that I said I would make, and so once I have the amended instructions, I will have my staff distribute them to you for your review. We're gonna take a break. We've been at this almost 2 hours, so my court reporter needs a break, my staff needs a break, and I'm sure you folks need a break. During the break, I'm gonna have my staff distribute to you the modified introductory instructions for the sentencing hearing if they haven't distributed them already.
We have them, Your Honor.
You have them? Okay, I'll give you a chance to review them. Again, I've made in bold font any changes, or I've tried to do that, so I'll take a break. You folks can review them, and then we'll proceed from there, and then perhaps we can talk about the courteous advisement and any allocution advisement as well at that point, okay?
How long?
How long do you need?
Maybe slightly longer than the normal break, like half an hour, just to make sure we can get through these.
I'll
if
have
that's
my
okay.
I'll have my staff check with you,
Okay.
and then when you folks are ready, I'll come out,
Okay.
okay? All right, thank you. The court will be in recess.